So after the first class, we are meeting. So now the next topic of discussion is what are written constitutions and what are unwritten constitutions? How are they different? So the basic understanding of this topic will help you to develop your conceptual clarity. And we will take the Indian Constitution as the representative of the written constitution, and we will take the British Constitution as the representative constitution of unwritten constitutions. So if you look at the various constitutions of the countries, that you will find that United Kingdom, New Zealand and Israel are the three countries which have unwritten constitutions. Whereas the rest of the countries, they have written constitutions. When we say that a country has an unwritten constitution, it doesn't mean that the constitution is not written down. The provisions of an unwritten constitution are also written down. They are printed and published. The provisions of an unwritten constitution is to everybody's knowledge. But only thing is the provisions are not organized. So we will begin with the definition of a written and unwritten constitution. First of all, what is the definition of a written constitution? An unwritten constitution is one whose provisions, have not been codified into a single legal document. So this is the definition of a written constitution. So a written constitution is one whose provisions have not been codified into a single legal document. Provision means whatever that is written down in a constitution. For example, the 450 articles that are found in the Indian Constitution, the clauses and the subclasses, the 25 parts of the Indian Constitution, the 12 schedules of the Indian Constitution, all of them are collectively known as the provisions of the Constitution. So these provisions are all codified. Codification means systematic arrangement. These provisions are all well organized in a logical order. So there is a method that is found in the organization of these provisions, and every provision of the written constitution have been collected into a single legal document. For example, the written constitution of India is all contained in a single document, the Constitution of India. The provisions of the Indian Constitution are not found outside this document. It is found in a single document. For example, in order that India is called as a sovereign country, it should satisfy certain characteristics. Without some defined territory, there can be no country. So therefore, a country should first and foremost have a territory. And territory alone does not constitute a country. For example, the Antarctica is a huge landmass, but it is not a country because nobody lives there permanently. So therefore, the territory should be populated. There should be population living in the territory. And there should be an organized government to administer the territory and the population. So then only it can be called as a country. And if that country is independent, then it is called a sovereign state. Before 15th August 1947, India was not a sovereign state because it was not independent. So therefore, the four attributes of a sovereign state are territory, population, government, and independence. And if somebody asks you that what are the attributes of a sovereign state, which was once a question asked in the prelim test by the UPSC, if you say the attributes are population, independence, territory, and governance, you are not organized in your presentation. Whereas if you say that these attributes in this order, you have a logical order in which that you present your answer. Without territory, there can be no population living. Without territory and population, there can be no organized government. And without the first three, there is no question of that territory being independent. And if you follow this method, and if you call the Indian Constitution codified, you can see the same order in which the constitutional provisions have been organized. What is part 1 of the Constitution of India? Does it deal with population or government? It deals with the territory. So the union and its territories. Part 1 of the Constitution contains 4 articles, and the subject matter of all these 4 articles is the same, that is the territory of India. And part 2 of the Constitution, it should deal with the population. But population has many dimensions. We should first and foremost identify who are the citizens of India, because the population includes the citizens, the foreigners, the refugees, the asylum seekers, etc. So therefore, the Constitution proceeds to identify who are all the citizens of India in part 2 of the Constitution, which is the citizenship. And the citizens should be provided with certain rights. And these are political, economic, and social rights. And thus, that part 3 of the Constitution deals with one aspect of the rights of the citizens, that is the civil and political rights, that is the fundamental rights. And part 4 of the Constitution, it deals with the economic and social rights of the citizens. The directive principles of the state policy are nothing but your economic and social rights, which the state must extend to you. What are directive principles? They are essentially your social and economic rights. So, and thereafter part 5 of the Constitution, it deals with the government. And we have 3 levels of government: the union government, the state governments, and the local self-governments. So therefore, the entire Constitution is organized in a logical order, and that is what is known as codification. So therefore, there has been efforts taken to organize the Constitution, codify the provisions, and get everything collected at one place. Right, now what is the unwritten Constitution definition? Its provisions have not been codified. An unwritten Constitution is one whose provisions have not been codified into a single legal document. For example, if you take the British Constitution, which is unwritten, the provisions of the British Constitution are not found in a single document. They are found scattered in various documents, legal documents of the country. Certain provisions of the British Constitution are found in the form of, say, Magna Carta. Some provisions are found in the form of laws made by the Parliament. Some provisions emerged out of nowhere. Historical accidents. So therefore, that the unwritten constitutional provisions have not been gathered and put at a single place. So the provisions have been left to remain where they are as they emerged. Why is it so? That we will see little later. So that is the definition of an unwritten constitution. The second difference is a written constitution is an enacted constitution, whereas an unwritten constitution is an evolved constitution. Right. Enacted constitution means that a constitution which has been brought into existence by a single authority. And what was that authority in case of India? The Constituent Assembly of India. Who was responsible for the Constitution of India, for making the Constitution of India? It was the Constituent Assembly. No other authority was involved in the making of the Indian Constitution. And an evolved constitution, what is it? An evolved constitution is one whose provisions have been made by multiple authorities, not a single authority which contributed to the emergence making of a unwritten constitution, but there were multiple authorities. For example, during the ancient and medieval times, the kings were absolute rulers. There was no parliament, legislature, there was no judiciary in that sense. All the powers of the country were all converged on the king himself. The king was the executive. He was the prime minister or the president. He was the legislature because he was the law-making authority. There was no legislature to make law. Whatever he spoke was law. Then third, that the king was the fountainhead of justice. He dispensed justice to the people. So he was absolute ruler. There was no control or authority over him. And in England, in the 13th century, that a king was so authoritative, autocratic, that the people revolted against him and fought against him and defeated him in a battle. And the people forced the king to sign a document known as Magna Carta. So the Magna Carta was the first written document which aimed to control the powers, authority of the king. It is a short document consisting of 6 provisions, just 6 provisions. And one of the provisions says, the king shall levy and collect tax without the approval of the people. So for the very first time, the financial powers of the king were restricted. The king can collect taxes from the people only with the approval of the people. Or the king was subjected to financial control by the people. Then the Magna Carta says that the king shall administer the country on the basis of certain agreed rules. So certain restrictions were placed. And Magna Carta is regarded as one of the parts of the unwritten constitution, which was signed in 1215 Common Era. So the British Constitution is at least 800 years old or even older than that. And there was a parliament in existence when the Magna Carta was signed. But the parliament was merely a deliberative body. It used to assemble, debate and make requests to the king. Please make law to protect our commercial interest. Please make laws to protect our social interest. The parliament had 0 powers. But now, when the king agreed that hereafter he shall levy and collect tax only with the approval of the people, it became practically difficult to go to the people every time the king wanted to levy tax. Because of this, it was agreed that the king would seek the approval of the parliament whenever he levied taxes. Thus, the first power the British Parliament got was not law-making power. The first power that the British Parliament got was financial control over the king. And that is what is incorporated in Article 265 of the Indian Constitution as well. The Magna Carta influences Indian Constitution. What is Article 265? It says that no tax shall be levied and collected by the executive without the approval of law. So therefore, the parliament got its first power. So to begin with, the king had all the powers, the parliament had no powers, and the Magna Carta conferred one power on the parliament and equally restricted the power of the king to that extent of financial control. And whenever the king subsequently became autocratic, the parliament representing the people fought against the king. So much so the parliament even beheaded a king for defying the parliament. So whenever the parliament succeeded in controlling the powers of the king, new provisions of the constitution emerged and the powers of the king got reduced. And today what is the power equation between the king and the parliament? The parliament is all powerful and the king has almost no powers in England. So this journey in power equation between the king and the parliament is the story of the emergence of the unwritten constitution of England. Therefore, parliament also contributed to the emergence of the new provisions of the constitution. So whenever the parliament restricted the powers of the king, new provisions emerged in the unwritten constitution. Therefore, the parliament also contributed to the growth and development of the unwritten constitution of England. In fact, the parliament largely contributed to the growth and development of the parliament or the constitution. Then the third is historical accidents. Nobody planned, but it so happened that certain events took place in the history of England which resulted in the addition of new provisions to the British Constitution, unwritten Constitution. For example, in 1714, the Queen of England, she died without leaving a legal heir to the throne. And by the time the parliament had established that only a Protestant can accede to the British throne. No Catholic or no any other Christian denominations can accede to the throne. And there was no Protestant heir to the throne available within England. Therefore, the British Parliament invited the Prince of Hanover in Germany to become the next king of England. Hanover was a principality, like a panchayat today in India, which can be compared. He was a prince, he was not a king, prince of a panchayat. He was the next legal Protestant heir to the throne, and he was invited by the British Parliament to become the King of England. He happily became king. From prince, he got a big elevation to become the King of England. At the time when he became King of England, there was a cabinet. But the cabinet was appointed by the king, and the cabinet was headed by the king. The cabinet meetings were held under the chairmanship of the king. And the cabinet was answerable, accountable to the king, but not to the parliament. But what is the cabinet form of government mean today? The cabinet is headed by the prime minister. It is accountable to the parliament. So initially it was accountable to the king. And when the Prince of Hanover became King of England, he took the title of George, King George I. He was 45 years of age at that time. He did not know English language. He did not know the way the British political system operated. When he presided over the cabinet meetings, he did not understand much of the deliberations. After some time, he stopped attending the cabinet meetings. Historical factor. And in the place of the king, the cabinet elected one among its members to become to head the cabinet. Thus, the cabinet system, as we know, emerged purely because of accident. The king refusing to attend the cabinet meetings. And the head of the cabinet, that he started communicating all the decisions of the cabinet to the parliament. So this is how that the head of the cabinet is prime minister, and the cabinet shall be accountable to the parliament, emerged as a principle under the British Constitution. And the poor man, the first prime minister, he died without knowing he was the first prime minister of England, because they recognized the office of the prime minister long after the death of the first prime minister. And he occupied the house at 10 Downing Street. The same tradition they continue. The Prime Minister of England continues to occupy 10 Downing Street, which is the official residence, which is a historical accident. Similarly, the powers relating to the Speaker of the Parliament, the bicameral legislature, all of them emerged due to historical accident. Therefore, many authorities, they contributed to the growth and development of the unwritten constitution. Whereas the Indian constitution, when it was enacted, it had the 395 articles. All these 395 articles were enacted at the same time. Whereas the various the articles of the British constitution, they emerged not at one time, but some provisions emerged today, some emerged tomorrow. Over a period of 800 years, these provisions, they emerged in small measures. That is why they are called evolved constitutions. So the Indian Constitution was made within less than 3 years by the Constituent Assembly of India, from 9th December 1946 to 26th November 1949. It was made, but it took more than 800 years to make the British Constitution. Right. The third difference is, in a written constitution, who came first? The constitution or the parliament? In a written constitution in India, who came first? The constitution or parliament? The constitution came into existence first. And the constitution later created the executive, legislature and the judiciary. Who created the Indian parliament? It is the Indian constitution that created the Indian parliament. And why we regard the parliament as the supreme law-making authority? Because the constitution says so. So, therefore, the executive, legislature and the judiciary are creations of the constitution. Whereas in England, who came first? The parliament came first, and it largely contributed to the growth and development of the constitution. So the roles of the constitution and the parliament are reversed in a case of a written and unwritten constitutions. As a result of this, who is supreme in a written constitution? The constitution is supreme. Whereas in an unwritten constitution, who is supreme? Who created whom? The parliament created the constitution, therefore parliament is supreme. So this is the single most important difference between the written and unwritten constitutions. Now you all know that parliament is supreme in England, but now you know why it is supreme in England. Suppose 4 options are given and you are asked to identify the essential difference between a written and unwritten constitution. The most important difference is this. Written constitution generally means the constitution is supreme. Unwritten constitution means the parliament is supreme. Then the fifth difference is, in a written constitution, the judiciary enjoys wider powers. So in a written constitution, the judiciary enjoys wider powers. Whereas in a unwritten constitution, the judiciary enjoys restricted powers, not wider powers. Now, what do you mean by wider powers, restricted powers, and why is it so? Now, in case of a written constitution like that of India, who is supreme? The constitution is supreme. And the constitution has conferred much of its powers to be exercised by the executive and the legislature. The bulk of the powers of the constitution are given to the executive and the legislature to be exercised. And their actions are positive because they have to decide about the policy measures, external, the foreign policy, domestic policies, defense of the country, then the financial regulations, everything. And suppose if the executive and the legislature misuse their powers and they violate the constitutional provisions, what will happen to the supremacy of the constitution? Will it remain intact or will it get diluted? Diluted. Therefore, it is essential that the powers of the executive and the legislature are controlled so that the constitutional supremacy is maintained. It is for this reason, to control the powers of the executive and the legislature, the constitution created the judiciary. So in a sense, judiciary is an afterthought. The primary function of the judiciary is to protect the constitutional supremacy by exercising control over the powers of the executive and the legislature. And thus that the judiciary is given power which is known as judicial review. The constitution confers the power of judicial review on the judiciary, where the judiciary uses this judicial review both against the executive action and legislative action. Any policy of the executive which violates the constitution can be declared as unconstitutional and void by the judiciary to protect the constitutional supremacy. Similarly, any law made by the parliament which violates the constitutional provisions can be declared by the judiciary as unconstitutional and void. So therefore, the judiciary exercises this judicial review, power of judicial review, both against the executive and legislative actions. Therefore, it is wider powers. And thus, the executive and the legislature have been given the sword by the constitution. Whereas the judiciary is given what? Shield by the constitution. Essentially, the powers of the judiciary are protective, to protect the constitutional supremacy and also to protect the basic rights of the citizens. So much of the powers are given to the executive and the legislature. Whereas in a unwritten constitution, who is supreme? Parliament is supreme. Suppose if the judiciary exercises control over the parliament, where the judiciary can declare an act of the parliament as invalid, can you still call the parliament supreme? If the judiciary enjoys the power in England to declare a law made by the British Parliament as invalid, can the British Parliament still be called supreme? No. Because of this, in England, the judiciary enjoys the power to declare an action of the executive as invalid. It does not enjoy the power to declare a law made by the legislature, Parliament, as invalid. So because of this, it is restricted power. The judiciary enjoys restricted powers where judicial review is available only against the executive action but not against the legislative action. So because of this, judicial review is well established, whereas here judicial review is partially established. Who will check the power of the judiciary? Ultimately, the people will have to, the public opinion will have to check the powers of the judiciary if it goes. So that is why that the concept of judicial review under the Indian Constitution is based on the US Constitution, not on the British Constitution, because judicial review is not completely established under the British Constitution. Right. The next is, the sixth difference is, in a written constitution, the constitution is either rigid or flexible or both. So a written constitution can be either rigid or flexible or both. So what do you mean by a rigid constitution? It means it is difficult to amend. So in what way the difficulty in amending the constitution is measured? Is it on the basis of majority? No. A constitution is rigid if its amendment to the constitution involves the role played by two or more authorities. Rigid constitution means the constitutional provisions cannot be amended by a single authority. And the constitutional provisions are amended by a coordination between two or more authorities. A flexible constitution is one whose provisions are amended by a single authority. For example, in USA, a constitutional amendment bill is passed by the Congress, which is the Parliament of the USA. Of course, with a 2/3 majority, that the Congress passes a constitutional amendment bill. Thereafter, the constitutional amendment bill shall have to be ratified by not less than 3/4 of the state legislatures. So the Parliament alone cannot amend the constitution. It needs the cooperation of the state legislatures to amend the constitution. Therefore, how many authorities are involved in amending the constitution in USA? The central legislature and the state legislatures, two levels of authorities are involved in amending the constitution. It is for this reason that the US Constitution is called rigid, not because that it is amended by a special majority of 2/3. Whereas in Sri Lanka, what happens? A constitutional amendment bill is passed by the Parliament. Of course, there also the constitutional amendment bill is passed by the Parliament with 2/3 majority. Thereafter, it doesn't need any ratification by the state legislature because there are no states. There are only provinces. And thus the constitutional amendment becomes a constitutional amendment act on getting the assent of the president. So here a single authority, legislative authority, is involved in amending the constitution. Therefore, it is flexible. What about India? A constitutional amendment bill is passed by the Parliament with 2/3 majority. And 90% of the provisions of the Indian Constitution can be amended by the Parliament alone. Thereafter, the bill is presented to the President, and on getting his assent, it becomes a Constitutional Amendment Act. However, there are certain provisions of the Indian Constitution which are to be amended only when the Constitutional Amendment Bill is also ratified by not less than half of the state legislatures. 28 states and the 3 union territories of Pondicherry, Jammu and Kashmir and Delhi. They are also involved in the amendment to the Constitution. So the UPSC looks into this kind of minute details to set questions in the prelims. So therefore, bulk of the Indian Constitution is flexible because it can be amended by the Parliament alone. But certain provisions, minor provisions of the Constitution are rigid because the states are involved in the ratification. So therefore, the US Constitution is totally rigid. The Sri Lankan Constitution is totally flexible. The Indian Constitution is both flexible and rigid. What about unwritten Constitution? Is it flexible or rigid or both? So here, the Congress attempt to amend the Constitution can be nullified by the legislatures. Therefore, the Parliament here cannot be called supreme. Whereas here in case of UK, that if the Parliament has to be supreme, then the Parliament cannot share the responsibility of amending the Constitution with any other legislature. Therefore, in England, the Constitution is necessarily flexible. The Constitution has to be necessarily flexible. Both constitute the Parliament, and the House of Lords almost has no power. So you cannot compare it with the Rajya Sabha in India. The Labour Party has already declared if it is elected to power in the next general elections, it will get the House of Lords abolished. So there will be a unicameral legislature. The House of Lords cannot even protect itself. The lower house is all powerful.
For India, when we talk about the Parliament passes the bill and President signs it.
The President shall sign the constitutional amendment. He has no choice. It's only a formality. Yes. Right. Now the next is a written constitution is either federal or unitary, depending upon its provisions. So what is the logic behind 31 and 50? There are 50 states in USA. There are 28 states in India plus 3 union territories. That's the logic. So why there is only 3 union territories? Of course, there are 7 union territories in India, but only 3 of them are large enough in terms of population to be provided with a legislative assembly of their own, elected legislative assemblies. And judicial activism and judicial review are 2 different issues which we will discuss later. Right. So a written constitution is federal, like that of US Constitution, Indian Constitution. Nepal's constitution is also federal. Pakistan's constitution is federal, where there are 2 forms of government, the central government and the state governments, as you know. And there are written constitutions which are unitary, like Bangladesh. What about China? With the sheer size of its territory, is it unitary or federal? It is unitary. It's not federal. In order to maintain the central control over the entire territory, that it is administered as a unitary country. Whereas a unwritten constitution, is it unitary or federal? What is the central point of federal constitution? Sharing of power between the center and the states. If the central parliament shares powers with the state legislature, can you call it supreme? So therefore, it's always unitary. In order to maintain the supremacy of the parliament, that the unwritten constitution is always unitary, it is not federal. Then the next difference is the written constitution is governed largely by its own provisions and less by conventions. So a written constitution is governed mostly by its own provisions, and the role of the conventions is limited. But what are conventions? Conventions are those practices and customs which are not written down anywhere in the legal documents, but are considered to be legally binding on the executive, legislature, and the judiciary. So they are not written in the constitution or in any statutory law. Nowhere they are written down, these practices, but are legally binding. For example, in India, we have certain practices which have become conventions. If the Speaker of the Lok Sabha is elected from the ruling party, and what about the election of the Deputy Speaker to the Lok Sabha? He is elected from the opposition. Where is it written? In which legal document that this practice is written? It is not written in the Constitution. It is not written in any of the laws made by the Parliament. It is not written even in the rules and regulations, notifications, orders, directions issued by the executive. Nowhere it is written. So this is what is known as convention. Even though it is not written down anywhere in a legal document, it is regarded as legally binding. Since 2019 to 2024, the opposition parties could not agree upon a common candidate to be elected as the Deputy Speaker. The office of the Deputy Speaker remained vacant. And the BJP party never tried to fill up the post of the Deputy Speaker by electing its own nominee to the Deputy Speaker. It is a convention which is used only at the Parliament level, but not at the state level. The states do not follow this. It's a practice. It is for convenience. That Pandit Nehru, he agreed that the opposition party should also be given an opportunity to preside over the proceedings of the Lok Sabha so that there can be no more floor coordination between the opposition parties and the ruling party. There can be greater the peace and stability with which that the debates can be organized in the assembly. So the same convention continues. Similarly, if a council of ministers is defeated in the Lok Sabha on a no confidence motion, what follows? The council of ministers shall resign. There is no other choice. So immediately within a reasonable time, the council of ministers shall submit its resignation to the president. So this convention is not written down anywhere in the constitution. Nowhere the constitution says the defeated government on a no confidence motion shall resign. Nor any of the laws made by the parliament, nor the rules of procedures followed in the Lok Sabha. It's also a convention. The third convention is that the constitution says the time interval between two sessions of the parliament shall not be more than 6 months, which means arithmetically speaking, if the parliament meets twice a year, the constitutional requirement is fulfilled. But actually the parliament meets in how many regular sessions? 3 regular sessions. Where is it written that the parliament shall meet thrice a year? It's again a convention. So therefore, the role of such conventions in for the constitution to administer the country is very low. The constitution is governed more by its own provisions and less by conventions, whereas in England, the constitution is governed more by conventions and less by provisions. So the role of the conventions in a unwritten constitution is higher. Then the last one is, there is a marked distinction between the constitution and other laws. There is a marked distinction between the constitution and other laws. So the constitution is clearly demarcated from the other types of laws. The constitution, statutory laws, ordinances, then bylaws, etc. So we know the difference between this is constitution, these are all non-constitutional documents. There is a distinction made between these. The statutory laws made by the parliament, they do not become part of the constitution. They remain outside the constitution. The BNS Acts, Bharatiya, the Nyaya Sankhit. So it is a statutory law which remains outside the constitution. Whereas in England, there is no marked distinction between the constitution and other laws. There is no marked distinction between the constitution and other laws. In England, every law made by the parliament automatically becomes a part of the constitution. There is nothing like statutory law. Each and every law made by the parliament in England automatically becomes part of the constitution. The thousands and thousands of statutory laws made by the parliament, they are outside the constitution in India. Whereas the same type of laws, if made in England by the parliament, they become part of the constitution. That is the reason why the constitution is bulky in England and it cannot be codified. It is so bulky. Today, if a law is made, the constitution becomes bulkier by that law. And if this year the parliament makes 10 laws, though all those 10 laws, they become part of the constitution, they contribute to the bulk of the constitution. You cannot codify the law, and that is why that the British constitution continues to remain an unwritten constitution. They don't want to get a constitution written. Because if England wants to have a written constitution, it can have it in 1 month. Constitute a constituent assembly, and the assembly will make a written constitution in 1 month will do. Whereas if India wants to have a unwritten constitution, it has to struggle for 800 years. So it is a unique character which the British do not want to miss, and they prefer the constitution to be unwritten because it gives a unique position to the constitution. For example, some of you must be collecting stamps, Philadelphia. And do you know a country which does not print its name on its stamps? For example, the stamps printed by India, the Indian government, they contain the name Bharat at the top and India at the bottom. Britain is the only country which does not print its names on the stamps. If you find a stamp without the name of the country being printed, it is presumed it is British stamp. That is because the stamp system as we know today was first introduced in England in 1840. And so they did not have to distinguish their stamp from the stamps of any other country. So the same practice continues. Likewise, that the stamp has a unique position in the postal systems of the world. Likewise, the British Constitution has a unique position among the constitutions of the world, being the unwritten Constitution. Right, any doubt? Bylaws, fourth is bylaws that you refer to the first class. Yes? No. No constitution is complete when it is made. The constitutional makers were not kings, were not gods, they were human beings. They could not anticipate all the future developments that will take and include provisions to govern those developments. So because of this, any constitution has certain gaps in it. And these gaps are filled up with the help of these conventions. So the conventions are actually made with consensus among the stakeholders. Wherever there is a gap, to fill up that gap, and if it is consensuously agreed, it becomes a convention. Right. Now the thematic topic for discussion. So how conventions are decided according to the needs of the situation on the basis of consensus, as I said. Right. The next topic is we will discuss the types of majorities that are used under the Constitution at the Parliament and at the state level, so that you don't have to discuss this separately later, and it will also becomes easier for you to compare and understand the various types of majorities easily. So the next topic, so before we see the majorities, let us see the constitutional provisions relating to the strength of the Parliament. So the Constitution says the maximum strength of the Lok Sabha as not more than 550. So the Constitution prescribes a maximum limit to the strength of the Lok Sabha as 550. 530 seats from the states and 20 seats from the union territories. So the Constitution does not fix the exact strength of the total strength of the Parliament. It only fixes the maximum strength of the Parliament. And if you want to raise this strength, you have to amend the Constitution. And the maximum strength of Rajya Sabha has been fixed as 250, that is 238 from the states and 12 nominated members. 238 members, elected members from the states and the union territories, and 12 nominated members. The statutory provision, what are the statutory provisions? So the law made by the Parliament has fixed the total strength of the Lok Sabha as 543. 530 from the states and 13 from the union territories. So total strength of the Lok Sabha is fixed by a ordinary law, the statutory law. And the total strength of Rajya Sabha has been fixed as 245. 233 elected members and 12 nominated members. So the majorities are worked out on the basis of the total strength or members present and voting, not on the maximum strength. The next is that what is this under Article 100 of the Constitution. The Constitution talks about the quorum in the Parliament. What do you mean by quorum? Quorum means the minimum number of members who must be present in the House for the House to sit and transact business. In order that the House can sit and do business, the business of debate, deliberations, discussions, passing of bills, resolutions, motions. So this type of official business can be done by the Parliament only if the quorum is met. And under Article 100, the quorum is not less than 1/10 of the total strength of the House. So the quorum is not less than 1/10 of the total strength of the House. And the quorum in Lok Sabha is 1/10 of 543, which is 54 or more. And does this number 54 include the presiding officer or not? Is the speaker included? Excluding the presiding officer. This is a convention, practice that is followed. So 54 members apart from the presiding officer. And quorum in Rajya Sabha is 1/10 of 245, which is 25 or more. This also excluding the presiding officer. So the Rajya Sabha includes members elected from the union territories also.
Is the deciding officer not considered the member of the House?
No, he is neutral. Therefore, that these 54 are going to debate, pass resolutions, etc. Plus, in the upper house, Rajya Sabha, the vice president who is the chairman, he is not a member of the house. Right, so these are the basic details. Now, what are the various types of the majorities? The first is absolute majority. Absolute majority. How would you define absolute majority? It means a majority of more than 50% of the total strength of the house. So absolute majority means more than 50% of the total strength of the house. So absolute majority is calculated on the total strength of the house. And absolute majority in the Lok Sabha is more than 50% of 543, which is 272 or more. So in the 17th Lok Sabha, there was no provision for nomination of Anglo-Indian members. So long as 2 Anglo-Indian members were nominated, the total strength was 545. Now since there is no provision for the nomination of Anglo-Indian members, in the last 17th Lok Sabha, it was 543. So 272 or more would constitute absolute majority. And absolute majority in the Rajya Sabha is more than it is 123 or more.
So with regards to the Anglo-Indian, the 2 seats that were set aside, so was it amended to remove it?
No, the nomination of 2 Anglo-Indian members to the Lok Sabha and assemblies was to be extended once in 10 years. The parliament did not extend it. No amendment was made, but it was not extended. So this is absolute majority. And since these figures are fixed for the time being, the absolute majority figures are also fixed, 123 and 272. Where used? What are the types of business where absolute majority is used? It is used to nowhere by itself. Nowhere it is required for the house doing business by itself. It is needed in association with other majority, which we will see little later. It is needed in combination with one more majority. By itself, it is not needed anywhere. It is needed absolute majority plus one more majority, which we will see later as we discuss. So therefore, absolute majority is not used very often by the parliament or the state legislatures while doing business. So legally speaking, it may not be very important, but politically it is extremely important, absolute majority. In the ongoing Lok Sabha elections, if any political party obtains absolute majority of seats in the elections held to the Lok Sabha, general election held to the Lok Sabha, then the combined strength of all the other political parties in the Lok Sabha is less than this figure, and thus that the government cannot be defeated on the floor of the Lok Sabha. Because of this, the government comes to the party, political party which obtained absolute majority of seats, comes to establish or form a majority government. Majority government means there is political stability and the government is likely to survive for the next 5 years. And majority government means that the government can totally concentrate on the policies and governance of the country. It does not have to worry about its political survival. It can take very firm decisions in a period of crisis, during a period of crisis. And a majority government is called the stronger government. Whereas on the other hand, if no political party obtains absolute majority of seats in a general elections held to the Lok Sabha, the emerging political situation is known as hung parliament. Hung parliament means no political party has obtained absolute majority of seats in the general elections held to the Lok Sabha or the legislative assemblies. And thus there is political instability. And the government that is formed is called minority government. And the minority government is a weak form of government, because the minority government may be defeated any time in the Lok Sabha. So it's a weak form of government. The minority government's primary task is to survive politically and then administer the country. Its focus is not entirely on the governance of the country, but its focus is more on its political survival. So therefore, we generally avoid electing a minority government. The Manmohan Singh government, in fact, that from 1989 to 2014, for 25 long years, there was minority governments formed one after the other. And only from 2014 onwards, for the last 2 terms, that we have a majority government. So the majority government is more preferable, but at the same time there should also be a stronger opposition parties to prevent the majority government to steamrolling the administration of the country. Right, so this is about absolute majority. Next is simple majority. So simple majority is known by very many names. They all mean the same. So what do you mean by simple majority? It means more than 50% of the members present and voting in a house. It means more than 50% of the members present and voting in the house. Whereas absolute majority is calculated on the basis of the total strength of the house, simple majority is calculated on the members who are present in the house and vote in the house. For example, in the Lok Sabha, the total strength of the house is 543. And on a given day, let us say that 523 members are present in the house, which means 20 members, they abstain from the house. They don't come to the house at all. And when a motion is put to vote, let us say that 520 members who are present in the house also participate in the voting. So these 3 members, they abstain from voting. These 20 members, they abstain from the house. And the simple majority is calculated not on the total strength. It is not calculated on the members who are present in the house. It is calculated on the members who are present in the house and also participate in voting. And the simple majority in this case is equivalent to 261 or more. So this is simple majority. For example, in another occasion, out of 543, only 250 members are present in the house. Maybe it is on the eve of the new year that there is big abstention in the house. And out of this, let us say 240 members actually participate in voting. So in this case, simple majority here means 121 or more. So therefore, the simple majority figures will keep on changing. They are not constant. They are variable depending upon the members who are present in the house. The term present and voting means that there is no proxy voting that is allowed in the parliament. If a member wants to cast his vote in the house, he shall be physically present in the house to cast the vote. No proxy vote is allowed. So this is simple majority. Is it clear? So why not 260? Then it is equivalent to, but it is more than 50%. It's not equivalent to, equal or more. It is more than 50%. Therefore 260 plus 1, 261. What if voting strength gets tied? Then the speaker, the presiding officer will have the casting vote to break the tie. So this is about simple majority. Now where used? The first occasion where simple majority is used is for the passage of a no confidence motion vote of thanks to the President's address, censure motion, adjournment motion, etc. So this type of motions and resolutions are passed with simple majority. Of course, these kind of motions, etc., will be discussed later in detail when the topic of parliament is taken up. Just to whet your curiosity, I will just give you the basic details relating to what they mean. No confidence motion can be introduced only in the Lok Sabha, not in the Rajya Sabha. It can be introduced only by the opposition parties. It is governed by the rules of procedures of the Lok Sabha. For the introduction of a no confidence motion, a minimum of 50 members of the Lok Sabha should support it. Then only it can be introduced in the Lok Sabha. And when the no confidence motion is admitted in the House, then all the pending business of before the House are set aside. They are adjourned, and only the no confidence motion is taken up for discussion and passage. If the no confidence motion is passed successfully in the Lok Sabha, which means the government has been defeated in the House, and the government has to resign, submit its resignation. No longer it can survive. However, if the no confidence motion is defeated in the Lok Sabha, which means the government has defeated the efforts of the opposition and the government has proved its majority in the House, and thus the government survives, that it continues to function, administer the country, and that is why that it is also called functional majority. For the government to continue to function, we don't need absolute majority, we need only simple majority. Or in other words, the government can continue to work in administering the country. Then the next is confidence motion. The confidence motion is not provided in the rules of procedures of the Lok Sabha. It emerged as a convention subsequently. For example, in 1979, when Chaudhry Charan Singh was appointed as the Prime Minister of India by the President gave a direction to the Prime Minister to prove his majority within 3 weeks. It is this point from where the confidence motion started getting introduced or getting part of the parliamentary procedure in India. So the confidence motion is introduced by the government to prove its majority in the Lok Sabha. It can be introduced and passed only in the Lok Sabha. The Rajya Sabha doesn't play any role on this. If the confidence motion is passed successfully, it amounts to the government proving its majority, it will continue to function. If it is defeated in the Lok Sabha, then the government shall resign. The first government that was defeated on a confidence motion was VP Singh government in 1990, that it lost the confidence motion and they resigned. Then the next is the vote of thanks to the President's address. Under the Constitution, it is mandatory that the President shall address both the houses of the Parliament assembled together at the beginning of the first session every year and also at the beginning of the first session that is held immediately after a general election that is held to the Lok Sabha. For example, the results will be out in June for the 18th Lok Sabha elections, and as soon as the government is formed, one of the first acts that will be done by the new government will be, it will organize for the President's address, where the President will address both the houses of the Parliament in a joint session. Now, the President's address is not prepared by the President. It is prepared by the Council of Ministers. The President's address is nothing but the achievements of the government in the previous year and the proposed policies and legislation that the government wants to introduce and get passed in the coming session. So it's a kind of policy proposals of the government. And the President is not responsible for the President's address. It is the Council of Ministers that is responsible for the address. Which means if the President's address is defeated in the Lok Sabha, the President does not have to resign, but it is the Council of Ministers that has to resign. After the President reads out the address, where she is expected not to change anything, she has to merely read out the address prepared by the Council of Ministers. So after the President reads out the address to the houses meet separately. And each house introduces a resolution known as the vote of thanks to the President's address. The meaning is to thank the President for having addressed the houses in a joint sitting. And a lot of deliberations take place on the vote of thanks to the President's address. And at the end of the deliberation, it is put to vote in the Lok Sabha. If the vote of thanks to the President's address is successfully passed by the Lok Sabha, then it is equivalent to getting a confidence motion passed. If the vote of thanks is successfully passed, it is equivalent to a confidence motion, the House expressing its confidence in the Council of Ministers. Whereas on the vote of thanks, President's address is defeated in the Lok Sabha, it is equivalent to a no confidence motion being passed in the House and the government has to resign. Now, the vote of thanks to the President's address is also deliberated upon in the Rajya Sabha. But generally speaking, the vote of thanks to the President's address is not put to vote in the Rajya Sabha, because even if it is defeated in the Rajya Sabha, it has no political impact. The government does not have to resign. Generally speaking, the Rajya Sabha deliberates on the vote of thanks to the President's address in detail, but thereafter that it just passes it without any voting in the House. Censure motion means to reprimand somebody officially. That is to find fault with somebody officially, that is known as censure. The censure motion can be introduced and passed only in the Lok Sabha. And the censure motion is introduced by the opposition parties against a minister or a group of ministers, but not against the entire council of ministers. If the censure motion is successfully passed in the Lok Sabha, the minister concerned alone has to resign, not the entire council of ministers. And the adjournment motion again is introduced and passed in the Lok Sabha. The adjournment motion is intended to bring the attention of the House to an issue of public importance. For example, if something very important has taken place, a member of the parliament can bring that issue for the consideration of the parliament and the government and demand a statement from the government on what measures the government is going to take. For example, that if Manipur was burning because of violence there last year, then a member of the Lok Sabha can introduce an adjournment motion in the Lok Sabha seeking the House to set aside, adjourn all the pending business before the House and take up this issue of public importance for debate. And at the end of the debate, the government has to make a policy statement what measures it is going to take to control the violence in the state of Manipur and bring peace and stability there. So therefore, the adjournment motion is to bring accountability to bear upon the government. Even though there is no adjournment motion that is introduced and passed in the Rajya Sabha, that there is another measure called calling attention motion, which is introduced and passed in the Rajya Sabha. In a sense, you can say adjournment motion is the same as the calling attention motion in the Rajya Sabha. So more about this you can learn later. Then the second type of business that is passed with simple majority is for the passage of ordinary money and financial bills. Ordinary money and financial bills. These three categories of bills are passed with simple majority. Whereas the constitutional amendment bill is passed with a special majority. There are only 4 occasions where if the government is defeated, the government has to resign. The first is when it is defeated on no confidence motion, when it is defeated on no confidence motion, when it is defeated on vote of thanks to the president's address, when it is defeated on a money bill. These are the only 4 occasions. If the government is defeated in the Lok Sabha, the government shall resign. On other occasions, it is not compulsory to resign immediately. So these are the types of questions which can be asked in your prelims, for example. Right. Now the next is for the election of the Speaker and Deputy Speaker. In the Lok Sabha and the Deputy Chairman in the Rajya Sabha. So these 3 officers are elected by simple majority. Then the 4th is for the passage of a resolution seeking the approval of both the houses for the continuance of President's rule and financial emergency. So what is money bill, what is financial bill, what is ordinary bill, we will all discuss under the topic of parliament. The focus of discussion today is the majorities, not money bill. So when the financial emergency is proclaimed in the country, it will continue only for a maximum of 2 months, unless within this 2-month period that the financial emergency is approved by both the houses of the parliament with a simple majority. Similarly, the president rule, which is imposed in a state under Article 356, is also valid only for a maximum of 2 months, unless within this 2-month period the president rule is approved by both the houses of the parliament with simple majority. What about national emergency? National emergency is to be approved by both the houses of the parliament with a special majority. What about discontinuance of national emergency? It can be done by the Lok Sabha alone with simple majority. For the passage of a resolution seeking the disapproval of the Lok Sabha, for the passage of a resolution seeking the disapproval of the Lok Sabha for the discontinuance of national emergency. So for the national emergency to be approved, it needs special majority by both the houses. For its disapproval, that Lok Sabha alone can disapprove so that it is discontinued, but with simple majority. Then the next occasion is wherever the Constitution does not specify the type of majority that is used. It is presumed to be simple majority. It is presumed to be simple majority. So if the Constitution wants a majority other than simple majority for doing business, the Constitution should specify the majority that is needed. If no majority is mentioned, it is presumed to be simple majority. That is why it is called default majority. By default, that the majority that is used in the parliament is simple majority, both in the parliament and state legislatures. For example, under Article 67 Clause B, so it talks about the removal of the Vice President. Article 67 Clause B, So it talks about the removal of the vice president. And it says a resolution seeking the removal of the vice president should be introduced only in the Rajya Sabha. A resolution seeking the removal of the vice president can be introduced only in the Rajya Sabha, where it is to be passed with the effective majority. So what is effective majority? We will see next. Thereafter, the resolution should be approved by Lok Sabha. So both the houses play a role in the removal of the vice president. So the resolution must be approved by the Lok Sabha. By what majority it must be approved? It is not stated in the constitution, therefore it is presumed to be simple majority. Similarly, under Article 368, a constitutional amendment bill shall be passed by a special majority in both the houses of the parliament. Any constitutional amendment bill shall have to be passed by both the houses of the parliament with a special majority that is mentioned in the constitution. And if the constitutional amendment bill needs ratification, then it should be ratified by not less than half of the state legislatures. By what majority it shall be ratified is not mentioned. Therefore, it is presumed to be simple majority. So this is what point number 6 means. Wherever the majority is not mentioned in the constitution, it is presumed to be simple majority. Therefore, the bulk of the business of the parliament and the state legislatures is done with simple majority. The majority which is more often used in the parliament is simple majority. Right. So,
The fifth point, so what do you mean by disapproval by the Lok Sabha?
For example, the opposition parties may introduce a resolution in the Lok Sabha for the discontinuance of the national emergency. For example, Indira Gandhi misused the provision, and such a resolution can be passed by a simple majority. If the Lok Sabha disapproves the continuance of the national emergency with a simple majority, the president shall revoke the national emergency. Whereas approval for the national emergency shall have to be given by both the houses of the parliament with a special majority. The disapproval of the national emergency can be done only by the Lok Sabha with a simple majority. So the constitutional amendment bill, for somebody who has asked the doubt, special majority is mentioned. For the ratification, no name of the majority is mentioned, therefore it is presumed to be simple majority. Then the third is effective majority. So it means a majority of more than 50% of the effective strength of the house. So it means more than 50% of the effective strength of the house. What is effective strength? Effective strength is equivalent to total strength minus vacancies. So effective strength means total strength of the house excluding the vacancies. For example, what is the total strength of Lok Sabha? 543. And let us say at a given time that there are 5 vacancies. Vacancies are caused due to what? Death of a member, resignation by the member, disqualification of the member under say anti-defection law and other means. So these are the grounds on which that the vacancies occurs. If a member abstains from the house, it does not amount to vacancy. So in this case, the effective strength, it becomes 538. And effective majority means, in this case, more than 50% of the effective strength of the house, which is 2, 6, it is 270 or more. Right, where is it used? Of course, we have seen under Article 67 Class B for the removal of the Vice President in the Rajya Sabha. For the removal of the Vice President in the Rajya Sabha. Then second, for the removal of the Speaker and Deputy Speaker in the Lok Sabha and Deputy Chairman in the Rajya Sabha. So these officers are elected by simple majority but removed with special majority. In case of abstention, so then it is members present and voting. If somebody is absent, so then it is not calculated in case of the effective strength. The effective strength is total strength minus vacancies. Out of these 538, 38 members may be absent, but still that the calculations will be based on 538. So the last one, special majority. So our quorum is applicable under all circumstances. minimum 54 members must be present in the Lok Sabha. Quorum applies for all types of majorities. Right. Now there are 3 different types of special majorities. Majority as under Article 360, Article 249. So there are 3 different types of special majorities. The first is the special majority as under Article 249. So what does it mean? It means a majority of not less than, it's not more than, it is not less than 2/3 of the members present and voting in the House. So two changes. It is not less than. It's not earlier. So far we have used that phrase more than 50%. It's not more than 2/3, but it is not less than 2/3, and it is 50% now has become 2/3. For example, in this case, suppose it is in the Lok Sabha or Rajya Sabha, out of 245 members, which is the total strength, let us say that 240 members are present in the house. All 240 of them participate in voting. Nobody abstains. Let us say. And what is this majority? Not less than 2/3 of the members present and voting. It will be 160 or more. So in this case, voting strength of 160 or more would constitute special majority of this type. Right. Now where it is used? So it is used under two occasions. First, please listen. Under Article 249, if the Rajya Sabha passes a resolution supported by not less than 2/3 of the members present and voting, that it is in the national interest or expedient, that the parliament may enact a law on the subjects that are mentioned under the state list. Then the parliament assumes the jurisdiction to enact a law on a state subject for a period of not more than 1 year at a time. You know that there are 99 subjects that are included under the union list. And only the parliament can enact laws on these 99 subjects. And the parliament's lawmaking authority is absolute. That under no circumstances the states will be able to enact on these 99 subjects. It is absolute. The authority the parliament enjoys over these 99 subjects. Now there are 61 subjects under the state list. And ordinarily the states have the authority to make law, to enact laws on these 61 subjects. But under extraordinary situation, 5 extraordinary situation, the parliament can also enact a law on these 61 subjects under the state list. Article 249 is one of those 5 extraordinary situations. If it is in the interest of the nation or it is expedient, necessary, then the Rajya Sabha has to pass a resolution with this kind of majority, authorizing the parliament to enact a law on one or more subjects that are specified in the resolution that are given in the state list. And the approval given by the Rajya Sabha for the parliament to enact on the state subject will be valid for a period of not more than 1 year. So it will be within 1 year the parliament can make law. The second occasion is under Article 312. The Constitution has created 2 All India services originally, the Indian Administrative Service and the Indian Foreign Service. All India Service means the officers of these services can work both under the central government and the state governments. And if a new All India Service is to be created, what is the procedure? The procedure is given under Article 312. It says if the Rajya Sabha passes a resolution supported by not less than 2/3 of the members present and voting, that it is necessary to create a new All India Service, then the Parliament may by law create a new All India Service within a period of 1 year. And that is how the Indian Forest Service was created as the third All India Service in 1966 by the Parliament after the Rajya Sabha had given the approval. Under both Article 249 and 312, the resolutions passed by the Rajya Sabha are not binding on the Parliament. The Parliament may or may not act upon the resolutions passed by the Rajya Sabha. The idea is that since both Article 249, 312 allow the Parliament to intrude into the state domain, such intrusion cannot take place without the approval given by the Rajya Sabha, which is the representative body of the states at the union level. And this type of special majority is used only in the Rajya Sabha, nowhere in the Lok Sabha. One speciality about this this majority is it is used in the Rajya Sabha, but it is not used in the Lok Sabha anywhere. Right, take down. Under Article 249, first occasion, under Article 249, if the Rajya Sabha passes a resolution, expedient means necessary. If the Rajya Sabha passes a resolution supported by not less than 2/3 of the members present and voting, supported by not less than 2/3 of the members present and voting, that it is in the national interest or expedient, that it is in the national interest or expedient that the Parliament may enact a law, that the Parliament may enact a law the Parliament may enact a law on one or more subjects that are given under the state list, then the Parliament may assume the jurisdiction. To enact a law on such specified state subject, on the specified state subjects for a period of not more than 1 year at a time. Right. Then second, under Article 312, if the Rajya Sabha passes a resolution, 312, if the Rajya Sabha passes a resolution supported by not less than 2/3 of the members present and voting, for the creation of a new All India Service, then the Parliament by law may create such a All India Service. The Parliament by law may create such an All India Service. So these are the two occasions. Then the next is special majority as under Article 368. So, how this special majority is different from the earlier one? So, under this special majority, two conditions are to be satisfied. In the earlier special majority, one condition, that is not less than 2/3 of the members present and voting. Here, this majority, it means a majority of not less than 2/3 of the members present and voting in the house, and by a majority of the total strength of the house. So the second condition is also to be fulfilled. Are we familiar with these two conditions? Or we are seeing these two conditions for the first time? This first condition we have just seen under Article 249. Have we seen the second condition earlier? Have we or not? Is it not the absolute majority? The second condition is nothing but absolute majority. By a majority of the total strength of the house is what is absolute majority. That's what I said earlier. Absolute majority is not needed anywhere by itself, but it is needed in association with one more majority. So special majority type A, or the special majority as under 249 plus absolute majority constitutes special majority as under Article 368. So this is how it works. For example, in the Lok Sabha, let us say a constitutional amendment bill is introduced for passage. And out of 543 members, which is the total strength of the house, then let us say that 523 members are present in the house. And out of these, 522 members, they actually vote on the constitutional amendment bill. What is not less than 2/3 of this? So 174 into 2. So this is 348. So let us say 348 members vote in favor of the constitutional amendment bill. Now this figure of 348 should satisfy both condition 1 and condition 2. Does that 348 satisfy condition 1? Yes, it satisfies, it makes it exactly 2/3 of the members. Does it also satisfy condition number 2? What is the figure that is necessary to satisfy condition number 2 in our Lok Sabha? 272. So therefore it satisfies both. The figure 348 satisfies both condition 1 and condition 2. Therefore the constitutional amendment bill is declared to have been passed by the Lok Sabha. Then the constitutional amendment bill goes to the Rajya Sabha. And in the Rajya Sabha, let us say out of 245 members, let us say 185 members are present in the house. And out of these 185, let us say 183 members, they are present and vote on the constitutional amendment bill. And what is 2/3 of this? 122. Let us say 122 members vote in favor of the constitutional amendment bill. Does this figure of 122 satisfy both the conditions? It satisfies the first condition, it manages to satisfy the first condition, it is not less than 2/3. Does it also constitute absolute majority in the Rajya Sabha? No. So because of this, the bill is declared to have been defeated in the Rajya Sabha. Because a minimum of 123 members must support the constitutional amendment bill in the Rajya Sabha, and a minimum of 272 members should support it in the Lok Sabha, subject to the first condition also being satisfied. So both the conditions are to be satisfied. Lok Sabha? 72, that is the absolute majority figure. Right, now next is, where is it used? For the passage of a constitutional amendment bill, by both the houses of the parliament. By both the houses of the parliament. Then the next is, for the passage of a resolution, by both the houses of the parliament, seeking the approval for the continuation of a national emergency. Seeking the approval for the continuation of a national emergency. Seeking the approval for the continuation of a national emergency. Then third, for the passage of a resolution in both the houses of the parliament, seeking the removal of a judge of the Supreme Court, a judge of a high court, then Comptroller and Auditor General of India, Chief Election Commissioner of India, State Election Commissioner. So all these 5 constitutional authorities can be removed by the President only if the approval is given earlier by the houses of the parliament, both the houses of the parliament. Then the fourth occasion where it is used, under Article 169, for the passage of a resolution for the passage of a resolution passed by the legislative assembly of a state, passed by the legislative assembly of a state, only the lower house, passed by the legislative assembly of a state, seeking the creation or abolition of the legislative council, seeking the creation or abolition of its legislative council by the parliament, by law. So only 6 states currently are provided with the state legislative council, the Vidhan Parishad. And if a state wants to create its own legislative parishad, it has to pass a resolution to that effect with this kind of majority. Thereafter, the resolution will go to the parliament. If the parliament by a simple majority enacts a law, then the legislative council stands created for that state. So many state legislatures, Assam, Rajasthan, Tamil Nadu, the Andhra Pradesh has its own. So many states have already passed resolutions under Article 169 for the creation of a legislative council for them. But the parliament so far has not acted upon that for the more than 10 years. So the resolution passed by the state legislature is not binding on the parliament. The parliament may or may not act upon it. Who is the authority to create or abolish a legislative council in the state? It's the parliament. Parliament is the authority to create or abolish, but the parliament can act only after such a resolution is passed by the state legislative assembly. Right, the last one, special majority as under Article 61. So this must have been discussed already. Article 61, you know that it provides for the impeachment of the president. So what it means? It means a majority of not less than 2/3 of the total strength of the house. Two-thirds of the total strength of the house. Like absolute majority, it is calculated on the total strength, but with 2/3 majority. So the earlier majority we have seen not less than 2/3 of the members present and voting, whereas here it is calculated on the total strength of the house. So this majority in the Lok Sabha means what? Not less than 2/3 of 543, which is equivalent to 362 or more. And in the Rajya Sabha, it means 2/3 of 245, 164 or more. Since for the time being, since the total strength is fixed, these figures are also fixed. Fine. So where is it used? It is used only for one occasion, that is for the impeachment of the president. Nowhere else it is used. So on alternate years, that the questions based on these majorities had been set in your prelims. If you answer the previous year questions, you would come across at least 3-4 questions over the past 10 years. have some good understanding of this and it is more logical to understand, then you will not forget. So any questions on this majority topic? Okay. Which one? Impeachment. Yeah, it can be introduced in either house of the parliament. What? The constitution, because the maximum strength fixed may not have to be followed because of the conditions, constituencies. For example, 20 members for the union territories may be more or less, maybe more. If some of the union territories are elevated to statehood, then you don't need 20 seats for the union territories. So therefore that flexibility has been given to the parliament. Right. So fundamental rights. Well, this is probably the most important topic under the Constitution, conceptually speaking. And if you have clear understanding of this fundamental rights topic, that it is these fundamental rights which are more often subjected to interpretation by the Supreme Court. So therefore, to understand the current developments in the field of Indian polity, you need to have a good understanding of the fundamental rights. Now I will just give you a short lecture and then I will give you a short notes. So what are fundamental rights? Why are only rights included under part 3 of the Constitution are called fundamental? So what do you mean by fundamental rights? So the fundamental rights are the basic rights or the foundational rights, which are the first category of rights which the citizen should enjoy. The other rights are over and above these fundamental rights, which are second category of rights, legal rights which are enjoyed by the citizens. The fundamental rights are also called the conscience of the Constitution. So the conscience means the human ability to understand what is morally right and what is morally wrong. Your ability to understand what is fair and what is unfair is what is known as conscience. So if at all, if the Constitution has its own conscience, where is that conscience found? The conscience is found in the fundamental rights and the directive principles of state policy. So these two are called the reposture of the conscience of the Constitution. And the fundamental rights of the Indian Constitution, they are based on the Bill of Rights of the US Constitution. Even though the British Constitution is the oldest constitution in the world, we do not follow our fundamental rights based on the British Constitution. We have modeled our fundamental rights based on the US Constitution. Because the US Constitution is the first written constitution, the oldest written constitution in the world. And second, the US Constitution was the first constitution to give a constitutional status and elevate the position of the fundamental rights. That is why we follow this Bill of Rights. Why it is called Bill of Rights? Why not the US Constitution? It is because when the US Constitution was made in 1789, it included no fundamental rights in favor of the individuals. The original US Constitution did not include a set of fundamental rights in favor of the individuals. But in 1791, the US Congress passed 10 amendments, the constitutional amendments. Amendments 1 to 10. And each amendment included one fundamental right in favor of the individuals. For example, Amendment 1, it included the right to free speech. Amendment 2, it included the right to bear arms, the right to bear arms. So likewise, 10 fundamental rights were introduced subsequently, and these 10 amendments are collectively known as the Bill of Rights. So therefore, our fundamental rights are based on the first 10 amendments to the US Constitution. Now the thing is, why the rights under Part 3 alone are called fundamental? Why not the rights, say, under the Constitution but outside Part 3 of the Constitution? The reason are two. First of all, no individual in this world is born as a waste, complete waste. Each individual has certain amount of talent inherent in him. And in order to develop this inherent talent in him, he must be provided with certain basic rights. In order to develop himself into a full individual, that he needs to enjoy certain basic rights. For example, that you may be endowed by nature with a creative thinking, that you are intellectually so gifted that you are able to think creatively, write originally, and spread new ideas for the benefit of the people. But if you are born in North Korea, where there is no freedom of speech and expression, your intellectual qualities will be of no use to you. Your intellectual capabilities, they keep developing over all your lifetime because of your freedom of speech and expression, where you can exchange your ideas with other intellectuals and it can continue to grow. So because of this, without freedom of speech and expression, your freedom, the creative abilities will be of no use. So similarly, that you may be born with the physical genetic makeup with which you can grow to be a 6-footer. But if you do not enjoy the right to health, the right to food, nutritious food, during the formative ages when you are growing up, you may not be able to reach your full potential height of the physical stature of 6 feet. So therefore, without fundamental rights, your capabilities, physical, intellectual, and spiritual capabilities cannot be developed to the fullest level. So that is why these fundamental rights are called fundamental in themselves. Further, without the fundamental rights, no democracy can exist and function. Unless there is freedom of speech and expression, that the society in which we live cannot be called a free society and open society. If the society is not free and open, that the polity that is practiced cannot be called the democratic polity. For these two reasons, that these rights are called fundamental rights. For example, in South Africa, when this apartheid rule was when the apartheid rule was practiced from 1920 to 1990 in South Africa, where racial discrimination was legally allowed, where on the basis of the color of the skin, the population had been given with certain privileges or denied certain privileges. Out of the 100% of the population, 19% of the population was white. And the whites alone were, during the apartheid rule, recognized as the citizens of South Africa. And they alone were given the voting rights. They alone can get elected to the parliament. They alone were allowed to occupy high constitutional officers like president, vice president, ministers, judges, members, etc. And only the whites were allowed to represent the country in international sports events. There were total segregation of the population, separate transportation for the whites and the non-whites. And the non-whites who constituted the majority, they were recognized as the nationals of South Africa without the citizenship rights, without the voting rights, and they were denied political and other rights. The whites, the non-whites, they were not allowed to represent the country in international events. For example, if you are born as talent to like Usain Bolt, who are born to run fast, if he had been born in apartheid South Africa, his total qualities would have gone waste. He could not have even realized that he had been born with such kind of talent. So therefore, the apartheid rule was an example of denial of certain privileges to the black population and conferment of certain special privileges on the one section of the population. That is why the United Nations and the rest of the world boycotted the apartheid rule, and no sporting activities were included for this. These people, the non-whites, were discriminated against. So the without fundamental rights, there will be discrimination that may be followed officially within a country, legally within a country. That is why the fundamental rights are very essential. Right, take down this introduction. The fundamental rights are based upon the fundamental rights are based upon the Bill of Rights of the US Constitution. Based upon the Bill of Rights of the US Constitution. The Bill of Rights is the collective name given to the Bill of Rights is the collective name given to the first 10 amendments. First 10 amendments passed to the US Congress. Passed by the US Congress to the Constitution. Passed by the US Congress to the Constitution. Where these amendments conferred 10 fundamental rights on the individuals. Conferred the 10 fundamental rights on the individuals. Full stop. The rights under Part 3 are called fundamental. Next sentence, the rights under Part 3 are called fundamental because they are essential for an individual. They are essential for an individual because they are essential for an individual to attain his fullest physical, intellectual, and spiritual stature. Fullest physical stature. Full stop. Without these fundamental rights, an individual cannot realize his full potential. An individual cannot realize his full potential as a human being. Full potential as a human being. Further, Further, the fundamental rights are essential. The fundamental rights are essential for the existence and functioning of a democracy. For the existence and functioning of a democracy. For the existence and functioning of a democracy. However, the fundamental rights that are enjoyed by individuals, the individuals are not absolute. They are subject to reasonable restrictions. That may be imposed by the state. They are subject to reasonable restrictions that may be imposed by the state on grounds that are mentioned in the Constitution. Right, so what are those grounds and what are the occasions they can be restricted? That I need time, we will discuss in the next class. So in the next class, I will briefly discuss what are civil rights, political rights, human rights, natural rights, economic rights, social rights. I will give you a brief introduction. So thereafter, we will start discussing the fundamental rights. Thank you. All the best. So please, M5 batch students, please collect your I-card at the ground floor today after the class. Now you can collect your I-cards.